what is happening around you. For instance, 13th June 2026. 13th, is it recording? Okay, yes. 13th June of 2026, the High Court has ruled that marriage certificate is not the only proof in property disputes after divorce. Okay, so he already shall create an update in at the back of your head. So the next session, when we'll be having now oral sessions, we will have read deeply to what this decision entailed, and kama kuna hiyo decision you share to the group. Now this is how we'll be handling the same.
Okay. So you have placed the slides. Placed kama slides kwa one PDF.
Yes.
It's a good one. You will share, then we'll see it. Okay.
I'll share the same, yeah.
Okay, go on.
Okay, then we have PwC, where Kenya publishes a draft regulations to operationalize the Virtual Asset Service Providers Act of 2025. So this one, at least on notes kidogo, the National Treasury has published the draft Virtual Asset Service Providers Regulations of 2026 for public participation, issued pursuant to the Virtual Asset Services Providers Act. The regulations seek to operationalize the framework for licensing and regulating the activities of virtual asset service providers. Okay, so scope and application, this is the key takeaway, is that the regulations apply to all persons offering virtual asset services in or from Kenya. Importantly, a person is deemed to be operating in or from Kenya, where that person derives an economic benefit or income from Kenya, regardless of physical presence. Moreover, the regulations are to be read together with the Act and other relevant legislations, including the POCAMLA Act, the Prevention of Terrorism Act, and Computer Misuse and Cyber Crimes Act. The regulations appear intended to capture offshore platforms deriving economic benefit or income from Kenya, even where they do not have a physical presence in Kenya. The practical scope of enforcement will likely become clearer over time. So if you are asked by any panel, at least you have the scope, you have the reason, the rationale of bringing this virtual asset service providers regulations into play. Then another update, we saw referee Omar Artan gifted 50,000 US dollars, an equivalent of 6.5 million, by a Somali businessman after being denied a visa to the USA for the World Cup championships. Even the FIFA itself decided to make him chair lead when it comes to the next World Cup session. They said that they'll make him the lead referee, and they'll also compensate him at 200,000 US dollars in form of compensation. So the legal issue arising from this update is, to what extent can the FIFA have power over another country's borders, of which they said they don't have any powers. They had to abide by the US ban on Somali travels because they are blacklisted as part of the countries that will not be eligible for visa to United States of America. This comes after various corruption allegations arising from Somali US residents in government. Then another key takeaway, we have the law of impeachment. So this begs one question to the students, that you must have understood what the law says. Maybe Ringera, you can try this on your feet. What the law provides for impeachment of the deputy president, or why is there a lacuna? Is there a direct impeachment procedure for the president, and what are the recommendations that the court gave to the legislators? So these are the kinds of updates that the panel will expect to ask a student. So maybe can we answer this during the next oral sessions after we have done research?
Yes.
Because it requires one to have read the Rigathi Gachagua decision.
Yes, and
do
you have a copy of this?
Yes, I sent to the group, but I'll forward the same. In fact, you can do a case brief once we resume to our current affairs on, remember tulisema ni Monday to Friday 10 to 11 pm every day ni orals. So in orals tunapeana chance for current affairs, then tuna delve into various questions that confuse students na course outlines venye mnaona tukifanya.
Okay,
then another okay
seen the decision you share. I'll do a
case brief.
Yes, I'll do a case brief.
Thank you.
Yes.
Thank you. Then another arising matter was on the appointment of, not the appointment, but the interview of Mr. Joseph Kipchumba Kigen Katwa, eyeing for the position of the Supreme Court judge, because he is now an honorable member of the Court of Appeal. And the key issue that the panel is likely to ask a student is on the duty to recuse and duty to sit. Okay, so there is a paper that was written by Honorable Ibrahim during volume 1 Supreme Court publications, and in this paper he has written directly on the title of the recusal of judges and the duty to sit, and in particular I'm specialized back in the Supreme Court, the duty to recuse yourself in the Supreme Court. Okay, remember, once you recuse yourself in the Supreme Court, the Supreme Court do another person to bring on board so that the number can balance. The threshold is a bit higher. Okay, so if you compare with what the law now provides, students should have read the Bangalore principles. You should read on Judicial Code of Conduct Act. Okay, so there is that. Is it an act? I'll confirm. But here under the enabling provision, section 3 all the way to 11, being about independence, honesty, integrity, professionalism, integrity. Okay, hizo zote lazima you should be in a position to gauge. Alafu pia Honorable Ibrahim aliproceed pia na kusema the threshold or test that will be used when it comes to a judge kujirecuse, that na zimekuwa overly zikikuwa applied in decisions where a judge akona direct influence in the matter, interest, a family member, commercial interest, even how you do social media gatherings. Remember pia this year kuna various judges after being promoted, they went online wakisema they are doing a party, and in that activity kukatokea people, advocates who appear before them, ika create pia public perception. So pia one of the tests ilikuwa pale in avoiding pia social media presence in a way that inaonekana uko na influence in certain things, so you are regulated if during occasions, harambees, to what extent can you contribute. So those are the things that an examiner or the panel will expect to see whether you know the thresholds zenye zimekuwa laid by the Judicial Service Code of Conduct. So that is it. Then if you check Tuju disappearance case, Kibera Law Court orders former CS Raphael Tuju to appear. So remember, this is a criminal element part, na nimecover hapo pia chini where Tuju was seeking for bail, anticipatory bail. So do you know the threshold for you to be given an anticipatory bail? Do you know how to make an application for anticipatory bail? And by the fact that the laws are provide expressly that this is where you will use anticipatory bail, where when you are drafting your application for anticipatory bail, under what provision will you try to convince the court? As we talk, najaribu pia kuangalia my criminal procedure code analysis. I see whether kuna mahali niliweka niliweka hiyo aspect ya anticipatory bail, because anything is possible with CLE. Now we can't ignore any aspect. Pia kwa orals unaweza ulizwa, kindly advise a person mwenye ako likely to go to be arrested. So na skim through Okay. Okay. Bail and bond. Natafuta. Provisions as to bail. Okay. Okay, so basically, because anything is possible, we won't ignore. Generally, courts interpret section 123 of the CPC to mean that bail is generally available at police station level and in court, and that the High Court can step in to admit to bail or reduce bail set by police or a subordinate court. What are the other elements? How do you do an application for bail or bond pending trial? Okay, so you approach court through a notice of motion being brought under section 123, 1 to 2 and section 123A of the Criminal Procedure Code. And in this notice of motion, take notice that the accused or applicant shall apply to this honorable court for orders that the accused or applicant be admitted to bail and bond pending trial on reasonable terms. 2, in the alternative, the accused or applicant be released upon executing a bond without sureties or what we call on recognizance, or on the least restrictive conditions the court deems fit. On recognizance is where you are telling the court, hey look, mindajileta tu, it's a gentleman agreement with the court. And grounds, the applicant is ready to attend court whenever required and has a fixed abode. There is no evidence of likelihood to abscond, and or the applicant has strong community ties. So this is where you disclose even the business that you do, the employment or where you work. There is no demonstrated risk of interference with witnesses. The applicant undertakes to comply with any reasonable conditions, including reporting to any nearest police station if ordered. So those are the grounds the examiner will expect to see in this application. Then at times you can be told to do an application to review or vary bail terms. So an examiner anaweza kuandikia that this client is aggrieved by the terms zenye amepatiwa na subordinate court. How will you now approach the higher court for review? So this is where you do an application under a notice of motion being brought under section 123(2) and section 123A of the CPC, and the orders that you will be seeking is that the bail and bond terms issued on this date be reviewed and varied to reasonable terms, substitute the same with cash bail or on bond or reporting conditions. And the grounds that the examiner will be interested in is to see that the terms are excessive and unattainable given applicant's means and therefore operate as a constructive denial of bail and changed circumstances since the last order. And then you have a supporting affidavit in both applications. So basically you can also be told to do an application to reduce bail or admit to bail. So the same application still suffices, same provisions of the law. What are the unique things hapa kwa hii application to reduce bail or be admitted? That the bail or bond is excessive contrary to section 123(2) of the CPC and is not proportionate to the applicant's circumstances. The terms are unattainable and amount to a denial of bail, and the applicant has a fixed abode. Okay, so at least hapo tumeona various applications that can arise from that section. Okay, so I'm looking for one. Kama I did one for, remember for anticipatory bail is not provided in the law in a borrow from conduct from practice rules, appeal from and revision of orders. Remember 2026 April criminal litigation paper iliuliza watu to draft a petition of appeal plus memorandum of appeal. Okay, so be keen, at least ukisikiza our session you will have to understand why people failed that paper. The paper even asked on joinder of counts and persons. How exactly do you know how to draft a charge sheet? Ama ni kitu tu unajua from notes? Do you know to do an actual drafting? Ukiambiwa draft a certain count like last year what they were told to do. Okay, those are the emanating things. So in this situation, we must understand how to do an anticipatory bail. And from what I had read is that anticipatory bail, okay, itakuja under an application under 123, section 123, because there is no other explicit rule. But the grounds that the examiner will expect to see is that are you at a threat of being arrested? Okay, those are the things. Because the courts will not want a position where you are using anticipatory bail application to defeat the ends of justice. So what are the conditions that you want the court to grant? Do you want the court to grant maybe a certain timeline? Maybe you are outside Kenya, maybe you want to travel back to Kenya, ufike ndo usishikwe ukiwa airport. So the court can even give directions on travel, ukuje, alafu you avail yourself in a police station within 72 hours. Okay, those are the conditions, because anticipatory bail is in a lapse wakati umekuwa arraigned in court na ukakuwa charged. Okay, so hapo anticipatory bail in a lapse. So those are the nitty-gritties zenye examiner to expect. How do you approach court with this application? Hii kuna mtu aliuliza hii swali kwa class, alafu watu wakachanganikiwa. There was a person who said that you approach court through a notice of motion. Mwingine akasema originating summons. But after due diligence, I found that you approach, it is a constitutional violation on a claim that your right is going to be infringed. Okay, so the examiner expect to see a constitutional petition, but in a court brought under certificate of urgency, now where you attach the application. Maybe so to avoid a situation where in a gaze, I'll do one analysis of the drafting, muone how I've interpreted. Ama mtu kama akona an example hapo online ya anticipatory bail, unaweza tusomea tusikie. Will I draft a constitutional petition? Is it a constitutional relief? Ama I'm begging the court person to a notice of motion. So let me search sahi anticipatory bail in Kenya application. Alafu naingia pale images to see whether there is any existing. Haya, good. Let me see this one. Anticipatory bail. Hope itafunguka sample. Inscribed. Haya, skiza title. Republic of Kenya in the High Court of Kenya at Nairobi. Miscellaneous criminal application number this. In the matter of an application for enforcement of Bill of Rights and Fundamental Rights under Chapter 4, Articles 19 all the way to 29 of the Constitution of Kenya. And in the matter of an application by Maureen for an order of anticipatory bail, okay, or bail pending arrest. And in the matter of Constitution of Kenya violation of criminal procedure of on section 123 between these people, and you sue the Inspector General of Police and the DPP. Okay, so notice of motion. Unaona? Okay, under Rule 3 of the Court Vacation Rules, Articles 19 all the way to 29, Section 123 of the Criminal Procedure Code, inherent jurisdiction of the Honorable Court. When I may invoke the inherent jurisdiction, it is not provided. Take notice, so it is a notice of motion. Take notice that this matter be satisfied. Okay, the Honorable Court shall be moved on this date, thereafter for the hearing of an application by counsel for the applicant, for orders that one, that this matter be satisfied as urgent and the same be heard ex parte in the first instance. That this Honorable Court do grant leave to the applicant to be heard during vacation period. That the Honorable Court be pleased to appoint and or grant the applicant anticipatory bail or bail pending arrest for any bailable offense consequent to or arising from the alleged complainant. That this Honorable Court be pleased to issue such orders as will be just and proper for the protection of the applicant's fundamental rights under Chapter 4 and Articles 19 all the way to 29. That a day be appointed by the court for the applicant to appear before the police officers attached to Industrial Area Police Station or any other officer of a named police station together with his advocates. Okay? Unaona ashapeana the conditions zenye anataka court pia impatie. Which application is grounded on the following in your ads. Mnagojea ads ishe. because it's not a premium feature. So iko 5 hii mpaka tugoje 2 1 continue skip ad. So in this situation, which application is grounded on the following facts and grounds: that the applicant is likely to be arrested by police officers from industrial area. Unaona, already ashaonesha that the applicant is apprehensive of being illegally arrested on the directions of Twala Mohammed. So OCS ashapeana directions. The misaction by the police officers of persistently harassing and intimidating the applicant with unlawful arrest. So there is even conduct to show that you are risking to be arrested. There is a supporting affidavit to that application. Unaona, now looking at that application iko na mpaka stamps the advocates, so it means that this is an actual application that was taken to court, to the high court. So if you approach court bila kuweka hiyo title ya inakaa ni kama petition, okay, wengine naona wameingia through a certificate of agency, okay, so kuna wengine naona wameweka certificate of agency alafu wakaweka hiyo application, okay. So we can give a takeaway from this. I'll approach court using a certificate of agency if the ni agent, niweke notice of motion, alafu niweke supporting affidavit. But now the title lazima ionyeshe in the matters of articles this and this and this being breached. That's where the examiner will say au mtu anajua kitu anafanya. Even the parties that you'll sue, the DCI, the Inspector General, National Police Service, Inspector Director of Public Prosecution, Ethics and Anti-Corruption Commission, hizo zote the examiner will say that you duly know what entails with an anticipatory bail. So show my screen. Ni kama my presentation ime collapse. I have it here. Let me proceed. Copy. Microsoft Edge, good hapa. Share. So now it is visible. So hiyo tumecover extensively. So let me go back to the document. Haya. The other thing that ilikuwa ina trend ni the hearing of Rigathi Gachagua. So in this situation, the examiner will ask you what was the dominant issue arising, what was the confusing element, what is the gap that the court decided, was the compensation of 50 million fair in your view as the judge, how could you have decided in this matter? Okay, do they have a higher chances of appeal? Okay, both sides weigh the argument. So it is a decision yenye lazima we interpret, uisome kwanza, and that's something that I urge everyone to do. Read that decision yote tu, ukiwa tu kwa matatu nini, provided umeelewa that case, then you will be eligible for any question that can arise from the same at any given point, because hiyo co-predictions iko number 1 co-predictions. Court ruling on Gachagua impeachment sparks a legal debate. Then you have another angle of where the Kenya is introducing a facility, Ebola facility. Kenya to comply with court order on Ebola facility as outbreak spreads. So the panel can ask you, there is a court order stopping Kenyan government, but the Kenyan government is still going on to impose this Ebola facility. You are the judge, you are an advocate. What mechanism can you take against such activities? Can you go after the CS? Can you go after the president? Unaona, what are the remedies to the people of Kenya? Wanakuuliza swali ngumu intentionally because to see whether you are in a position to interpret whatever is happening in the country, now whether you can offer solutions to the public.
The new
Yes.
statute, National Disaster Management Act, it grants the president powers under section 30 to declare for a national disaster, national state of disaster. So, in difference to what happened in 2020 when the president locked down the country, it was just a state of emergency. See, but now for this one,
Yes.
they have added a new one, that if maybe a pandemic like corona ever came again, now this one will be a national state of disaster. And there are procedures in that act for public censorship and as in, now you all remember what comes with the lockdown. What comes with the lockdown is you control the masses. So I would urge you, as you are looking into this issue, please read that act. That act was signed into law on the 28th of May 2026. The next day after Utumishi. So Utumishi was at night, then the next day. That day when there was a national prayer breakfast, he signed 3 acts into law. And I think, Victor, you mentioned the other one in these same slides. In slide 1 or 2, there was this act that you have presented. It's called
Virtual Assets Providers.
Then there's a third one. I will look for the third act. There's a third act signed into law. So I also want, if Victor, maybe we can come up with just a list. Do you know even a list is a good one? Just a list of all the laws that have come into force late 2025, let's say for the last 1 year, just say 1 year from July last year. We just list the ones for July last year to this year. You just know what it provides. You just read the long title. You read the long title and the short title and an act of parliament to provide for this. You just understand what the act is about. You are good to go. Yes.
Good. Even Ringara, because you are in the current affairs, even if there are some amendment acts that came into play, I highly propose that. I highly propose. In fact, one of the things that we will do before Sikuishe, we must go through an amendment act. Okay, tuangalie how people write, how the legislators frame amendments. Hii tunaipitia deliberately because we are avoiding a situation where usually inakuja pale LWD we amend a statute, ingine tuambie to amend a provision of the constitution and you don't know where to start from. Nataka sasa tupitie the two. In fact, to avoid procrastinations, before tuingie LPM, we will have that session on its own. So Ringera, say after in the background as I'm presenting, look for amendment of a statute. Look for amendment of a statute. Anyone will be appreciated. We just want to read it, tuone the language. Alafu look for amendment of a constitution. Junajua kushaikuwa hata kama ni bill ishaijaribu kuwekwa of amending the constitution in this online spaces. So Ringera, that is a task on your feet. We must read the acts, the two acts and the amending of the constitution part of it, so that we proceed. Haya, so you tushasema, umesema about the National Disaster Act, the power that the president has conferred upon himself. Maybe pia Ringera ukitafuta, maybe you can also have maybe that act. We just have a look at any other thing in maybe yani suspicious in the legal sphere that pia the panel can ask. Another thing that created a debate in Kenya is on the cybercrime law, where inside Kenya's new cybercrime law, there is the intent, impact, and the battle against misinformation. So this also requires a research to know exactly what was changed. But if you are in a position to look at the current affairs session that nilikuwa nimeupload previously, nilikuwa nimeingia deep mpaka nikasema this was the section around section 31 thereabouts, where ilikuwa vague that kulikuwa na a vagueness flani, and the court said that that provision is vague, and so we will have a review of the same. Then another legal angle was on legal setbacks for Tuju as court declines to reverse property auction. So this now calls your attention to conveyancing procedures. This is the reason why nilisema lazima tushike hizo procedures. Remember, there is a full session on procedures of conveyancing in YouTube. Nilifanya deliberately because nimefanya procedures mingi zenye unaweza imagine. So court declined to reverse property auction. Are you familiar with the Tuju case? What was happening? Ni nini alikuwa ameenda majuu, sijui alikuwa amechukua loan. Can you tell the panel what was exactly happening? So this will also be answered in our session pale. Juu pia ni kitu ya kwenda kuresearch, we see what was happening na Tuju. Unaweza sikiza pia news articles, by the way, unaweza search Tuju pale YouTube and italeta vitu mingi za Tuju, you listen and that will be enough. The panel I expect unaenda pale kuchambua the law. Then if you are keen, there is also a hearing of Dr. Tatu Kamau's case seeking to legalize FGM. This was 6 years ago, but hii pia ni kitu inaweza arise pia. Is it ethical to legalize FGM? Is it ethical to legalize bang? Unaona, so those are the things. Juu ukiangalia hapo kuna Rastafarians. Is it ethical? Hizo ndio vitu pia random to what's your view on it. Then court strikes down controversial seed law ending over a decade of criminalizing the same. So this was also a Supreme Court decision yenye ili strike down controversial seed law yenye ilikuwa ina prohibit farmers from using their native seeds. Ilikuwa imeweka mandatory that you need to buy seeds from a recognized seed seller in Kenya, and that ingekuwa a challenge to local farmers over the same. Then there was another landmark on High Court. Court decriminalizes consensual sex between adolescents. So the High Court bars a blanket criminalization of consensual adolescent relationships. If you are to read the ODPP guidelines on sasa children sentencing, unapata that thereabouts of section 27 hapo of the Sexual Offences Act ilikuwa imesema where two consenting adolescents wanna have intersex, then that will be self-defilement. Unaona? So na basically ilikuwa inaangukia boy child sana, because it appeared that the parents of the girl child ndo walikuwa wanaenda ni kama wana prosecute in courts kijana ashikwe. So the High Court said no, that is a blanket criminalization. Let us now change things, na recommend to the legislature that there be some changes to that, itolewe to be unconstitutional, that now you are a minor and you are protected as a minor. So another thing that I'm also invoking you to know is the legislative process for the preparation of a law in Kenya. Remember, there is a finance bill. So the examiner pale panel anataka kujua, do you exactly know how the legislative process in Kenya works? So that juu pia pale wako na marking scheme yao, so they expect so that legislative process in Kenya, the steps, so that is good to ignore hii part pia. Let us look at what the parliament has published in regards to the legislative process of the same. So it is loading a PDF so that we see, hata ukiulizwa pia on your feet, you are in a position. So this is the legislative process published by the Parliament second edition, and in brief, because it's something that we have done all the way from primary school, stages of a bill. Before we fike kwa stages of a bill, let me see, isikuwe na omit, isikuwe na
stages of a bill, ina include pia
yes,
the whole process, meaning the whole legislative drafting process.
True. So that's why nimesema I don't want kwanza kujump into the bill, the stages of a bill. Juu unaweza ulizwa origination of bills. So this document imeanza na bills may originate from the following parts. The executive. This is to introduce to the house through a member of the house, a leader of the majority party or leader of the minority party through a committee of the house, mostly the chairperson. Then another way a bill may originate is where you have individual members of the National Assembly introduced to the house through the member sponsoring the bill. Co-sponsoring of bills is an additional alternative. Okay, so C, we have a committee of the House introduced to the House through the chairperson or a member designated by the committee. Then D, a parliamentary political party may also initiate. This is also known as a sponsor of a bill. So generally here we have a member of public may petition parliament pursuant to Article 119 of the Constitution, and the standing orders to legislate on a matter introduced to the House by way of a petition conveyed by the Speaker, member, and committed to the relevant departmental committee for action. And F, alternatively, members of the public can forward legislative proposals to members of parliament. So hii panel itakuuliza, kindly give us various ways of how the finance bill can be introduced to form a bill. Okay, so just briefly, the executive, we have 2 individual members of the National Assembly, we have 3, a committee of the House. Okay, so the House can form itself into a committee. Then D, a parliamentary political party, UDA inaweza peleka. Then a member of public may petition parliament, pia wewe in your own capacity. Then members of the public can give legislative proposal to members of parliament. Then introducing bills. A member wishing to introduce a bill or legislative proposal shall submit to the clerk of the National Assembly a draft proposal or policy document bearing proposals to introduce a bill. Such proposals may be driven by stakeholders, interest groups, citizen initiatives, or urgent public interest or party manifestos. A member of the public may petition Parliament to legislate or to amend an existing legislation. In this case, the report of the relevant committee will guide the House on how to proceed with the proposed legislation, and the bill is published thereafter. What is the procedure for processing bills by members' initiative? We have pre-publication scrutiny. A member wishing to introduce a bill needs to first present to the Speaker a legislative proposal in accordance with Standing Order 114 and shall ensure that the following requirements are met: a letter presenting the legislative proposal to the Speaker, a draft copy of the legislative proposal if any, a memorandum of objects and reasons for which the legislative proposal is made. 2. A statement on whether the proposal is a money bill or not. And 5. A statement on limitation of fundamental rights and freedoms, if any. Okay, so if you look at LWD questions, kuna times wanakwambia draft a legislative proposal addressed to the Speaker. So if you are being told to draft a legislative proposal, so the examiner also expects to see the mandatory nature of the things that ziko hapo. And some key takeaways nimeona pia zimekuwa reiterated hapo. Do you have a memorandum of objects and reasons for which the legislative proposal is made? Then mandatory. Do you have a statement on whether the proposal is a money bill or not? Will it affect finance or the treasury? Do you have a statement on limitation of fundamental rights and freedoms? Okay, so hiyo ni done. Let's say ume introduce the legislative proposal to the Speaker and you have met that threshold. The Speaker will subject the legislative proposal to a review to ascertain whether it conforms to the provisions of the Constitution, statutes, and the standing orders. The scrutiny includes establishing that the bill is drafted in the prescribed legal language. C. Where the Speaker is of the opinion that a legislative proposal is not a draft money bill, in terms of Article 114 of the Constitution, the Speaker will direct that the proposal be referred to the relevant departmental committee for pre-publication scrutiny in case of a legislative proposal not sponsored by a committee, or direct that the proposal be published into a bill in case of a legislative proposal sponsored by a committee. Hapo tukue tu clear, where the Speaker is of the opinion that a legislative proposal is not a draft money bill in terms of Article 114 of the Constitution, the Speaker will now take this proposal and will direct that the proposal be referred to the relevant departmental committee for pre-publication scrutiny. But in case of a legislative proposal not sponsored by a committee, he will direct that the proposal be published into a bill in the case of a legislative proposal being sponsored by a committee directly. D. A draft money bill is a legislative proposal whose implementation will incur commitment of public funds. Where the Speaker determines that a legislative proposal is a draft money bill in terms of Article 114 of the Constitution, the legislative proposal is referred to the Budget and Appropriations Committee. The committee, after taking the views of the Cabinet Secretary responsible for the finance, will recommend whether the bill should be published or not. So kama si money bill, alipeleka to relevant departmental committee. Kama ni money bill, anaipeleka kwanza kwa Budget and Appropriations Committee. And then the committee will take the views of the CS on finance. The Budget and Appropriations Committee shall consider only the money bill or financial aspects of the proposal and submit a report to the Speaker within 21 days of the receipt of the proposal. The report shall contain the views of the CS responsible for finance, a detailed examination of the manner in which the legislative proposal affects the current and future budgets and may include implications on tax measures. C. A recommendation on whether or not the proposal should be proceeded with. And D. Any other appropriate recommendation relating to money bill aspects of the proposal. G. When the Speaker receives the recommendations of the Budget and Appropriations Committee, he shall direct that 1. The proposal be subjected to pre-publication scrutiny before the relevant departmental committee in case of a legislative proposal not sponsored by a committee. Or B. The proposal be published into a bill in the case of a legislative proposal sponsored by a committee. Or C. The legislative proposal be not proceeded with. H. The departmental committee to which a legislative proposal is referred to for pre-publication scrutiny shall consider the proposal and submit a report to the Speaker within 21 days and advise him whether or not the proposal should be proceeded with or any other appropriate recommendation. Thereafter, the Speaker shall direct either that the legislative proposal be not proceeded with or that it be published into a bill. Lastly, if the legislative proposal meets the stipulated threshold and does not fall within the definition of money bill pursuant to Article 114 of the Constitution, it is referred to the relevant departmental committee for pre-publication scrutiny. Okay, then we go to publication of bills. Publication of bills includes assignment of a number to the bill and actual printing of the bill by the government printers. Before approving publication of a legislative proposal into a bill, the Speaker takes into account the recommendations of the relevant committee that undertook pre-publication scrutiny. In case of money bills, the Speaker must satisfy that the relevant departmental committee and or Budget and Appropriations Committee has taken into account the opinion of the CS responsible for finance. Once approved by the Speaker, the legislative proposal is published in the Kenya Gazette. Bills originating from the National Assembly are printed in green color, whilst those originating from the Senate are printed in blue color. Have you come across the Finance Bill 2026? Why is it in green color? Because it is emanating from the National Assembly. If it is in blue, it is originating from the Senate.
Wait.
Publication period. Yes? Bills originating from the National Assembly are printed in green color, whilst those originating from the Senate are printed in blue color.
And by originating, you mean that that bill was introduced into Parliament. Let's call it Parliament by a senator.
A senator? An MP.
Introduced into Parliament. I'm using Parliament in quotes. By a senator.
Oh yes. It
was introduced into the National Assembly. It was introduced by a member of Parliament or a women rep. Okay.
Yes. Yes, hata hivyo ndo nimeelewa. What is the publication period for bills?
Okay.
Manze LWD inaweza kuwa moto this year.
Hata pia ninashuhudia. Nashuhudia this wanakuja LWD. April ilikuwa criminal, last December ilikuwa personality.
Wallahi manze, wallahi. Lazima wafanye kitu.
Tupate kwa LWD.
So, publication periods for bills, alafu ndo tuingie stages of a bill. The publication period of a bill is the minimum time prescribed by the standing orders for a bill that has been published to be due for introduction in the House for first reading. In other words, this is the period between the date a bill is published in the Kenya Gazette and when it is due for first reading. At the end of publication period, the bill is deemed to have matured for first reading. stages of a bill. Bills in the House go through a number of stages. Number 1, first reading. A bill is introduced in the House for the first time by way of reading of the title of the bill by the clerk. The first reading is by practice in most countries a purely formal undertaking to introduce the bill to the legislature. Upon being read the first time, the bill stands committed to the relevant select committee for consideration. No debate arises and no vote is taken at this stage. The select committee proceeds to scrutinize the bill by calling in the sponsor of the bill, inviting various stakeholders, technocrats, and external experts pursuant to Article 118 of the Constitution, and later submits a report to the House that may contain proposed amendments to the bill. So currently the finance bill ndio ilimaliza hii part. Is that the position? Finance bill imemaliza first readings, ndio? Juu ilikuwa imeinvolve various stakeholders and comments from the public. And there was no debate. Thank you, Chadwick. There was no debate nor votes.
This issue. I remember there's a bill earlier this year. It is as if they read the bill and the bill was concluded as in they went all through these stages in about 1 or 2 sittings of parliament. I can't remember which one it was, but it happened. That thing has happened this year.
Okay.
I'll look for it and then I come with the exact facts. Let me look for it.
Okay. So then hiyo ni first reading tumemaliza. No voting, stakeholders informed, nini zimechukuliwa, select committee wali proceed to scrutinize the bill by calling in the sponsor of the bill. They read out the title of the bill and the clerk was the one who read the same. Then the second nini, okay, kuna kitu nimekuwa requested na wakili. Kindly convert for me in Word. Let me do so ndio alafu I revert back. But in the meantime, maybe Ringera unaweza kuwa ukiniconfirmia hiyo mambo ya amendment of a statute, amendment of the constitution, hizo lazima tupitie. Hizo I have a feeling kabisa. I have a feeling so let me ni kitu tu kidogo hapa na convert na mtumia, but you can take that time. Ama pia Chadwick, you can try to go to the next stage of appeal, tuone kama pia ingekuja on fit ndio na panel pale. Kindly tell us the finance bill, the stages itachukua to become maybe know out of your ukianguka ni sawa. Naomba tu hapa ni kukumbuka juu once unakosea hii kitu itakutoka.
Victor, so what
yes,
I was talking about it's actually an issue inaitwa fast track bills. So fast track bills iko na hata kuna some case law needs. So there's a case here unajua kia mtaka Speaker of the National Assembly imesema ni 2020 imesema challenge laws that were passed hurriedly without adequate debate or public participation. Courts held even when standing orders are suspended, Parliament must follow constitutional requirements, ensure public participation. Key principle: suspension of standing orders / suspension of the Constitution. Because when we talk about standing orders being suspended, that is in the state of an emergency. So, for example, if the president were to ever declare a national state of disaster, as per the act that was passed last month, then that means the country is closed. If the country is closed, standing orders they are suspended. So that's true. So if the standing orders are suspended, then Parliament would have to proceed in a manner that out of the contemporary, as in the normal process. Maybe they can even hold virtual sessions to pass bills, such things. You see, such accommodation, and I think these are that was the issue I was talking about in this process, this legislative process. You can have the contemporary, the full process, a number of readings in the house, a number of debates in the house, and such. You could also have a virtual session where members of parliament have come to say that we have passed this bill and we push it forward to go to the president for attention. You see? So a fast track bill. Because a fast track bill, for example, ni ile bill yenye ilipea KEMSA power. Kuna bill tulifanya 2020 around February ilipea KEMSA the powers ya ku take over the management of corona and everything. Now that is the thing I was trying to talk about. So I was trying to bring that now in line to nilikuwa nataka pia nitaje sasa hii National State of Disaster Act yenye ametengeneza. That maybe if you are asking a question, are there bills that can purport to if you have a national state of disaster, we are still not paying so much attention to the constitution at that point in time, because what you're paying attention to is maybe survival of the country or something. So if you have a bill that was maybe declared or passed without normal procedure, then I don't know if there's an issue there. But maybe it's far-fetched, but I was just talking about, it's called a fast track. The same way with fast track cases and such.
Wow, thank you Lingera for that. Najaribu kurudi back to my publication. Nime resume. That is a very great insight. Maybe you can do a research ndio ukuwe na conclusion of the same. To avoid a situation where tumebaki pending. So, second reading. At this stage, a bill is deliberated upon by the House extensively, and the main debate is on the principles and objects of the bill. At the commencement of this stage, the member in charge of the bill, also known as the sponsor of the bill, moves a motion for second reading, which takes the following form: that the bill be now read a second time. It is worth noting that no amendment may be moved to this motion other than an amendment to leave out the word now. Such an amendment, if approved by the House, defers the second reading of the bill to a future date. Okay, so the only amendment allowed at this part ni form yenye nimesoma, that the bill be now read a second time. So the only amendment, if approved, will defer the second reading of the bill to a future date, because it will read bill be read a second time to a future date. Moving a bill involves informing the House on the contents of the bill and its importance, including the anticipated benefits that the bill shall have on society. At the end of the debate on the second reading of the bill, a vote is taken by the House, and if the motion is passed, the bill proceeds to the committee stage, but if it is defeated, the bill is lost. If the bill is passed at the conclusion of this stage, any member wishing to introduce amendments may submit their proposals to the clerk at least 24 hours before the commencement of the sitting at which the part of the bill is to be considered in committee. This is to afford sufficient time for processing and approval by the Speaker for consideration of the amendments in the committee of the whole House. Okay? So hapo tumeona extensively what entails to kusema that you are removing a motion for the second reading. This is now the voting stage, and ikianguka hapa imeanguka. If you pass, you go to the committee stage. Committee stage. Committee of the whole house refers to an arrangement in which the plenary converts itself into a committee that is comprised of the whole membership, including, this is where we have members of the assembly. Hence, the committee is the committee of the whole house that is constituted to consider the bill in detail, clause by clause, which includes the title, preamble, and schedules contained in the bill. The committee is chaired by the deputy speaker or any member of the chairperson's panel. The member presiding over the committee of the whole house is referred to as the chairperson, as opposed to being referred to as the speaker in plenary. The chairperson's panel is composed of 4 members who assist the speaker and the deputy speaker in presiding in the house. Additional details on this procedure can be in fact sheet number 3 on procedure in committee of the whole house. Where amendments are proposed to any part of the bill, the committee considers the amendment and takes a vote on each of them. If the amendment is passed, it becomes part of the bill. At the conclusion of consideration of the bill at the committee of the whole house stage, the sponsor of the bill moves a motion seeking that the chairperson reports to the consideration of the bill to the house. In the event that the committee is unable to conclude consideration of the bill, the sponsor moves a motion that the committee reports to house the progress made thus far on the bill. Then you have the reporting stage. At this stage, the committee of the whole house resolves to return to the house, and the chairperson of the committee of the whole house reports to the house the committee's consideration of the bill or report on progress made thus far. Thereafter, a motion for agreement with the report of the committee of the whole house is moved, seconded, and question proposed and put. A motion for agreement is one that seeks approval of the house with the form in which the committee of the whole house has considered the bill. A member who wishes to have any part of the bill reconsidered in the committee of the whole house may move a motion to amend the motion for agreement seeking recommittal of the specific parts of the bill. The member may move the motion be amended by inserting the words subject to recommittal of clauses or schedule or title, as the case may be, of the bill. If the motion is agreed to, the house resolves back into a committee of whole house immediately or on a different day to be determined by the house business committee. During recommittal, the committee shall confine itself to the specific parts that have been recommitted. So a bill can move from the reporting stage to go back to the committee stage under recommittal. So remember, the committee stage and the reporting stage is still under the second reading stage. So in terms of yani numbering, we had first reading, second reading, then okay, the other stages are independent, but hawezi enda third reading kama hujapitia committee stage na kama hujapitia reporting stage. So that now you go to the third reading. This is the final stage of the passage of a bill through the house, known as the third reading. No further substantive amendments are taken up at this stage, though drafting amendments and renumbering of clauses may be accepted. Generally, there is very little debate during the third reading and a final vote is taken. If the bill does not concern county governments, the Speaker refers it to the President for assent. If the bill concerns county governments, it is referred to the Senate for concurrence. NB. The bill is lost if it is rejected at either second reading, committee of the whole house, or at third reading. So at the third reading, this is where another bill can be lost, or at the committee of the whole house, it can also be lost, and during the second reading. So if the bill does not concern county government, the Speaker refers it to the President for assent. If it affects county government, inaenda to the Senate. Laws that require consideration by both houses of parliament. According to Article 109(4) of the Constitution, any bill that concerns county government may originate in either house and requires consideration by both houses. Before the introduction of a bill that will require passage in both houses, the speakers of both houses of parliament consult and determine whether that bill concerns county governments. Bills that concern county governments include 1. A bill containing provisions affecting the functions and powers of the county governments. or a bill relating to the election of members of a county assembly or a county executive, and C, a bill referred to in chapter 12 affecting the finances of county governments. Okay, consideration of bills originating from Senate. Then you have operation and mandate of the mediation committee. This is also important. Once the National Assembly passes a bill concerning county governments, the Speaker refers it to the Senate for concurrence by way of a message to the Senate together with the bill in the form passed by the National Assembly. Whenever the National Assembly receives a message from the Senate seeking its consideration, the Speaker conveys the message to the House. The bill is read a first time and referred to the relevant committee. The House then processes the bill in the same manner as bills originating in the National Assembly. Remember, now we are at the consideration of bills originating from the Senate. In considering a bill received from the Senate, the National Assembly may either reject the bill at second reading, or consider and pass the bill with amendments, or consider and pass the bill without amendments and in the form passed by the Senate, or D, reject the bill at third reading. After considering and making a decision on the bill, the Speaker conveys the said decision to the Senate by way of a message indicating the decision of the National Assembly on that bill. A bill is committed to a mediation committee if the following happens. 1. The National Assembly rejects a bill received from the Senate at second or third reading, or the National Assembly rejects Senate's amendments to a bill originating from the National Assembly, or C, the Senate rejects the National Assembly amendment to a bill originating from the Senate. So there will be an appointment and composition of a mediation committee. Whenever a bill stands committed to a mediation committee, the speakers of both houses appoint equal number of members to mediation committee to consider that bill and communicate the decision to the other house. So the quorum of a mediation committee is a third of its total membership and should be an equal number of members from both houses. What is the operation and mandate of the mediation committee? The mandate is to attempt to develop a version of the bill that both houses will agree and pass. Presidential assent. Once a bill has been passed by the House, the Speaker, upon certification of the passed bill, presents it for assent by the President. The President may, within 14 days after receiving the bill, assent to the bill, in which case it becomes law and comes into effect within 14 days or on the date or period specified in the Act. B. He may refer the bill back to the House with a memorandum outlining reasons for the referral. If it is referred to the National Assembly, the Speaker conveys this referral to the House by way of a message and refers the presidential memorandum containing the recommended amendments to the relevant select committee for consideration. The committee considers the recommended amendments and submit a report to the House on them. The House reconsiders the bill whilst confining itself to the clauses to which the President has expressed reservation and is either passes the bill fully accommodating the President's reservation, following which the Speaker resubmits the bill to the President for assent, or B. passes the bill a second time without amendments, or passes the bill with amendments that do not accommodate the President's reservations. In order for the National Assembly to override the President's reservation, the House vetoes the proposed amendments by a vote supported by at least 233 members, which constitutes 2/3 of the National Assembly membership. Thereafter, the Speaker resubmits the bill for assent within 7 days, and the President is required to assent to it within 7 days. So hapo tumeona that who has the final power? It will be the House, and that marks the end. So maybe a brief outline. First reading, invitation, so reading by the clerk, the title, committed to the relevant departmental committee for consideration. We invite relevant stakeholders, holding public hearing, consultation, technical experts. Then we move to the second reading. This is the debate stage of a bill. So the sponsor of the bill moves it on the floor of the House. This marks the beginning. There is no voting here. And the bill, the Speaker authorizes the proposer to respond to any issues arising from related debates. Then we go to the committee stage. A committee stage. This is where the whole House form into a committee. wana scrutinize the bill, and they do so clause by clause. A report is made, then we go to the report stage. This stage marks the point where the report is presented to the House through a procedural motion. Then you have third reading. This marks the final stage of a bill in the National Assembly. Then you have to go to the presidential asset. Akikataa anapeana memorandum of amendments, then inakuwa read out in both houses. Wana form a committee if need be, only focusing on the amendments. Then it requires a membership of 233 members because it forms 2/3 of the National Assembly. They can even reject the amendments being proposed by the president. So that is it. That is it. So hapo we have extensively covered the legislative process for preparation of a law in Kenya. Another question in orals: court rules IG Kanja has full authority over police recruitment. So there was a time there was a battle between the roles of the National Police Service when it comes to police recruitment. Then courts embrace AI to streamline justice. You can be asked by the panel, how can Kenya School of Law use AI to streamline classes? How can law firms use AI? How can the courts use AI? So that is a question we are also expecting in LPM. We are also expecting an ethical question in professional ethics paper. We are also expecting an oral cross-examination from the lecturers on the use of AI. Then another matter arising was on 9 Utumishi students face court over fatal dormitory fire. That has been extensively covered by Ringera. Court suspends controversial cybercrimes law amid growing public outcries. Computer Misuse and Cybercrime Amendment Bill. In fact, Ringera, look for this bill. Look for this bill so that we read it, because this is one of the most likely amendment bill to be asked in LWD. Hii ni one of the top predictions zenye nimeweka.
Is it already announced?
Okay, siko sure about it, but kuna parliamentary tracker unaweza angalia pale, ukiingia parliament website unaweza track a bill and the stages yenye iko. But now for this one, only for purposes of LWD exams, niko sure kuna swali ya amendment of bills this year. So hii tutaipitia, hii tafuta, alafu tutafute moja ya amendment of the constitution. Let me see.
Hiyo amendment hapo imeandikwa date 2024.
Imeandikwa 2024.
Kuna act yenye iko in force, Computer Misuse and Cyber Crimes Cap 79C. Yes,
so there is an act.
This act may be cited as the Computer Misuse and Cyber Crimes Act. It was revised by kuna revise hapa ya 24th annual supplementary notice number 2221 of 2023, December 2022. So hiyo kuna hiyo unaongelea that's not so look for that.
Okay, so I want you basi ukipata hiyo amendment show us yes, the original statute, alafu show us the amendment, alafu utuoneshe how the amendment was incorporated. Because hiyo itakuwa imetusaidia badala ya kukram only how to amend, itatuonesha how words change from original amendment then now after the incorporation. Hiyo ni possible, si ndio? Yani agree nitafuta. Tumeipata. Haya, sasa tafuta the previous one alafu the new one. Zote una project. Sawa. So as you look for it, then kuna another matter arising ilikuwa ya lawyer Chacha Mwita remains in police custody as court considers extended timelines. So these also brought ethical questions on whether advocates can be arrested, and the answer is yes. The Advocates Act allows criminal matters, commercial matters, and disciplinary matters to run concurrently, simultaneously, so you can't use one as the bar of the other. Then imeleta new changes in that there is anti-terrorism compliance systems, and I predict that in our exam professional ethics there can be a question on POCAMLA Act, the duty to disclose anti-terrorism activities pursuant to the Anti-Terrorism Act huko. So this is also an area to focus in professional ethics. Then this here pia tunaweza pata a situation where the use of social media, how it interferes with the SOPEC rules. SOPEC rule pia ime describe on the use of social media. So we are also expecting to what extent can an advocate use social media by the surge of SpaceX, by the fact that mpaka kulikuwa na advocate and a dance in social media. Okay, so those are the things. Okay, so maybe to say how we will tackle this part is kweni kama ati nimeavoid in the SOPEC rules zenye nimeanalyze, I have given even case laws zenye advocate ashaipelekwa for disciplinary for use of a social media account. What is the threshold that you are required as an advocate to use a social media to do your education to the masses, etc. And what are the do's and don'ts? If you read the social media SOPEC rule, I think it's rule 12, as compared to the advertising. Okay, so lazima tutaweka advertising rules hapa, alafu tuweke SOPEC rule hapa. Okay, so that one munikumbusha when I'm doing SOPEC rules analysis, because hiyo nikiruka itakuwa deadly and fatal. Kama umeinua mkono unaweza unmute, sioni wala. Leo tumesema leo before niingie commercial juu nikoza outline na kupea hiyo chance ya utusomee, utuprojectie hiyo act, yani tuoneshe hiyo transition, the language used. Hiyo session nataka iitwe amendment of bills, alafu kutakuwa na amendment of a constitution. The language of amendment. Haya. So another key takeaway was on stakeholder engagement on quality of legal training. Remember pia wale watu si wajinga wenye wanaenda kutuliza maswali. Do you know the school motto of Kenya School of Law? Do you know the aims and objectives of the institution? Do you know there was a meeting, a stakeholder engagement meeting that saw the merger of KSL and CLE on testing examinations? What are the matters arising from that stakeholder engagement meetings? Unaona? So pia wanataka kuona, did you listen to the news? Iko available in the news. I nawatuma kwa news muone this stakeholder engagement on how and the various issues zenye zilikuwa discussed. Then High Court halts shutdown of Kenya Institute of Management amid deregistration claims. There was a time where the institute, the body zenye iko in charge of regularization of this sector, ilikuwa imederegister Kim's Institute by the fact that hawakuwa wame comply na some things, na ikasema those certificates awarded by this institution will not be applicable. So ika bring chaos to the public, and the High Court had to halt the shutdown of the same orders to be applicable. So this begs a question on judicial review applications, what mechanism will you use, what documents will you use when you are approaching court for judicial review applications. Do you know that you need to seek leave kama umeingia na ile Law Reforms Act? Okay. Do you know kama ni umeingia na the Constitution of Kenya Article 23 that you don't require leave? Okay, so those are the things that you should expect to be asked.
Victor,
Haya.
am I to understand that these are current bill for amendment of the Constitution?
There is, niliona kitu kama amendment of the Constitution. There must be. Yani, si umeipata? Sasa hiyo kwanza nataka tumalize statute alafu tuingie constitution. Juu huo wana alternate. Wanasemanga constitution this year, next year tuweke bill. But ukiangalia analysis of how students have been performing in those questions, watu wanaanguka. They don't know the language to use or what to rely on. Yani ni mtu ajai soma. Unajua ukishikwa na situation yenye ujui ni nini unaulizwa hapo utaanguka. So that is it. So immediately nimemaliza hii session, we will take a break. Utuambie time yenye utataka ku resume, then we resume. Jumi niko karibu kumaliza.
Okay.
Finance bill tumediscuss. But hatuja discuss ulisema Ringera ulipitia the key changes that are being proposed by the finance bill. That was well captured. Even in my previous section pia nilikuwa nime highlight iko sawa. Tuju staged abduction case. Hii tulisema through mambo ya anticipatory bail. Alafu pia unafaa kujua kitu ya habeas corpus where the state ndio imekuficha. How do you do a habeas corpus application? Iko in the part of the cause outline. So when you'll be doing criminal litigation cause outline review, we must know how to draft a habeas corpus application. What is the test applicable? Ni grounds gani nita attach in this application for me to be granted these orders? So then BCJ sues the Kenyan government for his illegal arrest and abduction. EP ilikuwa a matter arising 10 months ago. Then you have niliona nini zangu channel yangu sasa ina top up kwa searches za Legal News Kenya. This was an analysis of Laws of Succession Act Session 1 because Session 2 tunaenda sasa kuendelea from Section 29. So if anyone is willing, pezi ni vitu tunaweza endelea pia usiku. Kwani what will happen? Tutaendelea usiku. Kwanza tunaweza piga Law of Succession Act tumalize yote from Section 29. Juu ni very detailed na iko na key things. Kilifi detective claims lawyer tried to bribe him in a 32 million fraud case against 2 Italians. Okay, so ina raise mambo ya ethical conducts, bribery allegations. Nimekwambia sana italeta mambo ya anti-money laundering in advocates lazima. Hiyo kitu na suspect because pia kuna Kilimani, an advocate who was arrested in engaging in gold frauds. Now these examiners who wanaona hizi news. Then we have Joseph Irongo sentenced to death for murdering Monica Kimani. This is a landmark decision because it will test pia on the conduct of the ID parade. Itaturudisha back to the test of ID parade, person to the stand, national police standing orders, tuangalie the threshold, what are the requirements. Hiyo pia ni oral questions. Okay, so ni ID parade. Alafu pia itatuleta to the last seen doctrine. Panel anaweza kuuliza what is the last seen doctrine, how you should tie the same with the change should be so strong, circumstantial evidence. Kenyan abortion, women go to backstreet clinics amid legal ambiguity. So hiyo pia ni an important factor. Kenyan Law Society files contempt of court application against the government. Nakumbuka nikikuuliza the remedy that the government or the citizens of Kenya can use against the government because wame set up Ebola nini facility in Kenya. Okay, so these are the articles to read. Counterfeiting and the law in Kenya. Shiko hii style amekuwa allegedly subjected to pay around 45 million for you selling counterfeit products. So these are the things that are arising. Unaweza ulizwa tu randomly, what is the agency responsible? We have the Anti-Counterfeit Authority that is responsible for that. We have the Kenya Anti-Counterfeit Act of 2018. Okay. The Amnesty demands disclosure of whereabouts of abducted businessman amid deportation fears. So mambo ya deportation in criminal litigation. Extradition treaties. What is the extradition procedure in Kenya? What is the role of the AG versus the DPP when it comes to extradition procedures in Kenya? Unaona, hizi ni potential oral questions. The role of the AG is limited to executive procedure. The role of the DPP is the one anapatiwa orders na AG that nime receive a certain request from this state. Unaona, na tuko na act ya Extradition and Contingencies Act. Section 13 inasema I've received this notice. Kindly act on it. Prosecutor anachukua ile notice. Anakimbia na anatafuta anafanya an application pale kotini. An application seeking surrender of this person. Failure to surrender na kukujia, unashikwa. Unapelekwa kwa magistrate court. Magistrate court inakusikiza. Unaona? Inakusikiza, alafu ikisema uko na prima facie case inakurelease to the DPP. DPP wanaku deport. Magistrate court ikisema manzee hakuna prima facie case, there is nothing that the DPP can do. It's either appeal ama unini uachiliwe under a certain provision. Unaona? So these are the things that lazima zianze kuflow at the back of your head when you are reading such news articles. Extradition proceedings. Watatuletea hapo swali, a foreigner nini ameshikwa. Legal blunder. Court rules careless driving offense does not exist. A motorist was fined. So the High Court judge quashed the conviction of Daniel Mwangi and ordered that the 200 fine he had paid be refunded immediately. So court careless driving offense does not exist. So ilikuwa reported which year? Mta confirm. First war crimes complaint against Sudan's RSF filed in Kenya. So there is an regional legal affair arising. So this is an article for you to read. What happens in such situations? Victims of alleged atrocities linked to the war in Sudan on Tuesday asked prosecutors in Kenya to investigate allegations of torture and sexual violence by members of a notorious paramilitary group. Matter arising. Kenyan court hurls Safaricom Vodacom stake sale amid legal challenge. Hii iko part of the project works na tunataka kuipitia extensively tomorrow when we will be doing our project works. Then Kenyan court strikes down fake news sections of cyber law, upholds other problematic provisions. Hii ndo Ringera anakuja kutu projectia so that we see how the court dealt with cyber crime provisions. Ringera pia kama ni possible the decision that gave rise to that amendment pia inaweza kuwa poa kukua incorporated because pia unaona hiyo decision ni matter arising when it comes to the oral part. Then Kenyan court grants custody to American father in surrogacy case. Another key factor that you have to know when it comes to surrogacy is that the Children Act 2022 imesema directly that parental responsibilities cannot be signed or entered into a contract. Okay, so ni kama ime limit surrogacy parents when it comes to various rights. E.g. naming of a child iko a reserve to a parent, but in this situation who is the parent? It is the biological parent, and a surrogacy mother unaona kulikuwa na contract there in between. So inasema surrogacy mother has the right to name this child by the fact of protection accorded to her by the Children Act. But there is a procedure yenye, if you want the child to fully come to you as the surrogate now the party mwenye ananunua mtoto, unafaa kuwa umemaliza hiyo procedure na ukaenda in court for enforceability, ikakuwa sasa mtoto anakuwa legally yours. Unaona? So even surrogacy claims can even arise in probate situations. Unaambiwa certain mother alikuwa amebeba mtoto, the man anasema nini, the man hakufanya application to make this child to be his own, now the child anataka kuinherit. These are the matter arising zenye pia huwezi ignore. So in this decision, the court granted custody to American father in surrogacy case. Unaona ni April 2026. Okay, he entered into a gestational surrogacy agreement with a Kenyan woman, and on May 30th, they signed an agreement for her to carry the pregnancy to term. Okay. Tuju secures 200,000 anticipatory bond at the High Court. Hiyo ni ile application ya kurevise bond, maybe alikuwa amekuwa rejected. We have seen how we will approach court with that. What Court of Appeal ruling on abortion means for Kenyan women? Watauliza your argument, usiende pale kusema oh, it is ethically wrong. There is provisions, there is a case law. PAK, the landmark decision in Malindi. Kenyan High Court rules that unregistered foreign lenders cannot sue defaulting borrowers. 26th March. Nadi kuna some key decisions. In Stitching Robobank Foundation versus Avachem Limited, the Kenyan High Court held that an unregistered foreign lender did not possess the legal capacity to initiate legal proceedings against defaulting borrowers. Implications are that a foreign company shall not carry on business in Kenya unless it is registered under this part pursuant to Section 974 of the Kenya Companies Act. Then, how proposed traffic law changes vehicle detention in Kenya. So this is where we have motorists in the country are set to benefit from a proposed legal overhaul that will change how police detain vehicles and motor vehicles under the Traffic Amendment Bill of 2026, because gari mingi zinaharibikia police station. Kenya releases the national AI strategy. This is nakwambia on various angles that you can be told to apply the same. Landmark legal case identifies British fathers of children in rural Kenyan army base. Hapa examiner anaweza kuwa amechonga swali pale moja kali, that a British father ameacha a biological child in Kenya, and before aende akapeana gift, akapeana movable, akapeana immovable, the place of domicility. Unasikia kuna succession ilifanywa huko Britain. Unafaa kufanya ile resealing of a grant, advise this person. Hapo kuna maswali moto. Why reassignment of phone numbers is now a data privacy crisis? Mtu anapeana namba yako, Safaricom wanauza hiyo namba. So there are decisions to that effect. And even Section 27A of the Kenya Information and Communications Act and Section 40 of the Data Protection Act. It gives data subjects the right to rectification and erasure of personal data. When a number is reassigned, the telco effectively erases the subscriber's link to that data, but it does so without the subscriber's request and without any mechanism for the subscriber to object. The right to erasure becomes a right exercised by the telco, not by the data subject. That is the argument in unaweza raise to the panel. Consent under Section 30 of the Data Protection Act must be express, unequivocal, free, specific, and informed. A subscriber cannot consent to reassignment at the time of registration because they do not know the circumstances of the future of deactivation. The consent must occur at the point of deactivation. So basically, we have legal alert, a reprieve for lenders as court strikes down Section 47 of the Land Laws Amendment Act 2016. So that one was also a huge one. It was through a petition to declare Section 2, 38, 47, 48, and 49 of the Land Laws Amendment Act 2016 as unconstitutional, land null and void. That Section 47 of the Act had amended Section 12 of the Land Act and introduced the concept of controlled land, defined as land which is within a zone of 25 kilometers from the inland national boundary of Kenya, within the first and second row from high water mark of Indian Ocean, and any other land as could be declared controlled. Then lastly, Court of Appeal declines to suspend High Court orders barring national and county governments from hiring external lawyers, cites public interest, protection of public funds. This is just 28 minutes ago. So generally ukiona hizo news articles, hata wewe unaanza kukua well informed of what is happening. So Ringera pia we can take this mode yenye una combine hizi ma screenshots zote, unakuja unafanya one presentation, it avoid a situation where ume line towards one update ukasahau zingine. Remember hapa ni quantity, when it comes to orals ni quantity, kwa exam ni quality. Hiyo ndio niliona ni strategy. So Ringera, maybe you can give us time allocations when you intend to present for hizi bills, equal sessions on bills. Tuingie saa ngapi? Unajua hii ndio watumia personal wewe na Chadwick, because I want these people wasione ni kama hii kitu watu wa sacrifice, unaona? Yani ikwe ni kazi unafanya input. Juu angekuwa hapa unaona pia tungekuwa na diverse knowledge, si ndio? So siwezi kuwa ati nimekaa hivi nikaanza kupiga screenshots nikacombine, alafu nitumie tu watu kwa scroll through. Hapana. Hii na kutumia personally, alafu uko natuma link. Mtu anataka kufollow link, afollow link. Hii na watumia personal.
Msema tuanze na bill.
Yes, a bill sana sana.
Tuko na the one na
yes. Lakini hapo katikati usisahau kuweka hiyo amendment bill. Tutaiangalia hiyo amendment bill on its own, alafu tuangalie the previous ilikuwa inasema hivi, sasa imekuja kuchange hivi, sasa imekuwa hivi. Basi ya. Yes. Good. Yes. Okay. Okay. Thank you. Uanze na decisions ndio tupate background. Ndio tupate background. So that when you are presenting tuna relate. Sawa. Yes. Sawa, to that niko sawa. Sawa, acha ni save hii nitume huko.